Beginning January 2026, the Trump administration is imposing a pause on immigrant visa processing for nationals from 75 different countries. Let's get into what the pause is and what the pause is not. My name is Rahim Dhanani. I'm a U.S. immigration attorney. I've been practicing U.S. immigration law for more than 25 years. Okay, so this pause, you can still file an application. You can still have an interview at the U.S. consulate or U.S. embassy. But when you get to the point of the actual immigrant visa being issued, that is not going to happen because of the pause. And so if you're from one of these 75 countries, then you are not going to be able to get your green card and enter the U.S. as a permanent resident. So who's on the list of 75 countries? I'm not going to be able to go through all 75 in the video. I'll leave a list of the 75 in the section below the video, but some notable ones are Afghanistan, Bangladesh, Brazil, Colombia, Egypt, Ethiopia. Notably, India is not on the list. So if you're from India, if you're an Indian national, then this does not apply to you. So you lucked out. So let's get clear on 3 quick points about what this pause is and what this pause is not. It's a pause, so it means that it's not a permanent ban on people who have applications pending for immigrant visas overseas at the consulates or the embassies. You are paused, and presumably at some point the pause would be lifted. Also, this does not apply to people who are filing non-immigrant visa applications, which means that their stay is temporary. So people who are, for example, filing for tourist visas or H-1B or student or J-1 visas, those people are not affected by this ban because those are temporary visas. The people who are affected are people who are filing for permanent resident status, basically, and those are the immigrant visa interviews, and those are paused. If you're from one of these 75 countries and you are currently inside of the U.S. and you are filing for the immigrant visa while in the U.S., and you would be doing what's called basically adjustment of status, because you're adjusting from a non-immigrant status in the U.S. to an immigrant status, permanent resident status in the U.S. As long as you're doing that inside the U.S. without having to go to the consulate or the embassy abroad, you're fine. You can still adjust your status even if you're from one of these 75 countries. So those people are in good shape as well. There is one big exception for people who are processing overseas at a U.S. consulate or a U.S. embassy. So that exception is if you happen to be a dual national listed in that list of 75 countries, and you have another passport from a country that's not in that list of 75 countries, then you could still process your immigrant visa overseas. So for example, if you have a passport from Bangladesh, that's in the list of 75. But if you also have a French passport, then the French passport is not in that list of 75. So you could still process in the U.S. consulate overseas because you're a dual national. You're both Bangladeshi and you are also French. So that's a big exception and one to note. If you happen to fall in that category, again, you're somebody who has gotten lucky and you can go ahead and still process your immigrant visa. So obviously there's going to be some strategy. You're going to have to kind of figure out if you're overseas, what you're going to do, how long you're going to wait, what's acceptable. Similarly, for an employer, you might have to think about, can I have this worker do work for me while they're waiting overseas for the immigrant visa? Am I going to have some other option to bring them back into the U.S. and, get them back working for the company inside the U.S.? Those are all strategy issues you can discuss with your immigration attorney and figure that out. Hope that's helpful. I will talk to you guys later. Bye.